Well, good morning and welcome to today's webinar on competition issues facing the food sector. My name is Craig Hodgson and I co-lead the firm's food and agribusiness sector, and I'll be chairing the Q&A session today, which will last approximately 45 minutes, which will then be followed by an opportunity for you to ask questions for the final 15 minutes. The panel today comprises Kate Newman, Simon Elsegood, Nicola Holmes from our competition team, and they will discuss the CMA's policy priorities, the CMA's enforcement activities, and then finally we'll look at CMA's approach to mergers involving businesses in the food and agribusiness sector. The initial panel discussion will be recorded, but the final 15 minutes won't be recorded to just encourage us all to have a discussion towards the end of today's session. So to start, Nicola, what are the CMA currently thinking about in relation to food and agribusinesses?
Thanks, Craig, and good morning, everyone. So the CMA's annual plan for the period 24-25 was adopted in March, following a period of consultation. And the annual plan is useful because it really sets out their strategic focus for the coming 12 months. I think it's fair to say that the strategy they've adopted has really been informed by the environment they feel like they're working in, and that's really led them, they say, to focus their efforts or continue to focus their efforts on tackling cost of living pressures and concentrating on areas that they feel matter most to people. This is in particular by taking action in relation to areas of essential spending where household budgets might be under strain. They intend to really prioritise their efforts where they feel they're most needed and can deliver greatest value. So they definitely have one eye on showing the value that they can achieve. I think the key plank of this that's relevant to us today is their efforts to focus on cost of living pressures in the grocery sector. In 2023, they began their review of competition in the grocery sector to try and really analyse whether weak or ineffective competition between suppliers of products to the grocery customers had been contributing to high food price inflation. Their initial analysis last year suggested that they picked 10 product categories where they wanted to take a deeper dive to gain a better understanding around competition and price dynamics. So their 10 chosen categories were baby formula, baked beans, bread, chilled desserts, lemonade, mayonnaise, milk, pet food, poultry and ready meals, so a full spectrum there of different products that they wanted to do a deep dive on effectively. However, in December of last year, the CMA concluded that in fact across the whole food and grocery sector, high inflation had in fact been driven largely by rising input costs, particularly energy and the key agricultural inputs such as fertilizer. So the majority of those 10 product categories were under scrutiny were actually given a clean bill of health. The exception really was for infant formula. In that category, consumers, the CMA found, were less likely to switch away from brands. So perhaps new parents aren't best placed to do lots of careful shopping around for their infant formula. So they seem to be reluctant to switch away from brands. And the CMA is concerned that pricing for infant formula appears to be too high. So as a result of that, in February of this year, they've launched a formal market study into the supply of infant formula and follow-on formula in the UK. Just to unpack that a little bit, launching a formal market study allows them to use their formal information gathering powers. So they have the power to compel the production of information. In terms of timing for that, we're expecting their final report to be in around September of this year. Market studies allow the CMA to really examine why a whole market might not be working well for consumers without focusing necessarily on specific anti-competitive conduct by one of the players in the market. So there's a range of possible outcomes that they can get to following their study. This would include potentially making recommendations to government if they think there needs to be changes to regulation or public policy to fix the problems that they've identified. They might encourage businesses to self-regulate. In some markets, that's around the provision of better information to consumers, something like that. They might take sort of consumer or competition law enforcement action against specific firms. So if their whole market study did lead them to find specific conduct by particular players that they're concerned about, they could begin enforcement action. They could also make a reference for a more in-depth, a phase 2 market investigation, which is like looking at the market again, but it's in much more detail and much more rigorously. Or there is always still the option that for infant formula 2, when they dive more deeply, they will also conclude that they should be given a clean bill of health. So that's the sort of infant formula market study. But as well as that, they've also got ongoing work reviewing unit pricing for groceries and also loyalty pricing schemes in the grocery sector. So quite a lot on their plate.
Thanks, Nicola. We also hear an awful lot about sustainability and green issues in the sector. What's the CMA's current approach to these issues?
Yeah, we do hear a lot about it, and sustainability and the CMA's green claims work were also mentioned as key areas of focus in their annual plan. So again, the annual plan tells us what's important to them, and that's really high up the agenda. In October last year, they published their Green Agreements guidance, and that guidance explains the circumstances in which collaborations between actual potential competitors in order to protect or enhance environmental sustainability may or may not be permitted under competition law. So they're sort of sitting behind this. There was a concern on the part of the CMA, shared actually by other global competition regulators, that if businesses are worrying about compliance with competition law, that might be acting as a barrier to them cooperating in their sector with their competitors to produce genuine beneficial green initiatives that might not be achievable if everyone can't work together. So the CMA was really concerned that competition law shouldn't be a barrier or a block to genuine environmental initiatives that could produce real benefits. So they've published this guidance which sets out quite detailed analysis of different forms of potential cooperation between competitors, and gives some good examples of what may or may not be permitted. But sort of most importantly, I think in practical terms, is that it also establishes what they're calling their open door policy at the CMA, so that businesses that are considering entering into an environmental sustainability agreement with their competitors can seek informal guidance from the CMA. So they really want people to bring their thinking to the CMA for review and consideration. And to support that, they've actually just very recently published some additional guidance on how to actually use the open door policy. So the kind of forms and things that you need to fill in to give them the information that they need to consider your proposed initiative. And I think this open door policy is bearing fruit. So in December of last year, 2023, the first response to a request for guidance under this policy was published. This gave the Fair Trade Foundation comfort that their shared impact initiative was unlikely to raise competition concerns. So the guidance is published for the benefit of others who might want to see, what kinds of things the CMA is happy to bless. The specific initiative concerned the purchasing of various fair trade products and bananas, coffee and cocoa by UK grocery retailers. So the initiative involved a commitment on the part of those grocery retailers to use longer term supply agreements and to purchase additional products from the selected pool of suppliers. The objective of the agreement obviously being to give those fair trade producers some greater stability and certainty to enable them then to make investments to address various environmental concerns such as deforestation and tackling biodiversity loss and so on. So that you have that one from December, and then hot on its heels, they've just published their second piece of guidance last month, relating to a proposal by WWF UK Climate Action. So that is about reducing Scope 3 emissions in the grocery sector. So guidance is available on the CMA's website for others to have a look at, take advantage of.
So that sounds like the CMA is very supportive of the sustainability agenda. Does that mean that the CMA is happy to bless anything as long as it has green ambitions?
They are very positive, but not at all for everything. So the flip side of this work, kind of blessing and supporting a genuine green initiative, green agreements. The flip side of that is the work they're doing, enforcement work they're doing against greenwashing and unrealistic sort of sustainability claims. So they have just taken enforcement action against several fashion retailers, and they do have ongoing work in relation to FMCG products in relation to sort of greenwashing or false or misleading green claims. So I mean that's obviously focused so far. The enforcement action is focused kind of on fashion, FMCG, but for the food and agribusiness sector, I think there are some useful takeaways from that enforcement work. I think in particular, businesses must be really careful to be able to properly back up any green claims that they're making in respect of their products, and to ensure that the claims are fully justified and supported. And that includes both the kind of explicit claims, but also what you might think of as kind of implied claims, implications about the products you're putting onto the market. For example, the CMA has been quite clear that firms should not use sort of natural imagery like green leaves or the color green generally, and pictures of rainforest animals and so on, logos or icons that might suggest to a consumer that a product's more environmentally friendly than it actually is. In addition, statements around accreditation schemes or standards must not be misleading. It must be very clear, and a consumer must be able to access details about that scheme. So whether that's by providing links or pointing consumers to where they can find further information about what that accreditation scheme or standard actually means. I think in this space, we can expect to see ongoing activity because, in addition, complaints are always a real risk. And we saw some very recent press reports just last week suggesting that a Scottish campaign group has just lodged a complaint with the CMA over what it alleges are false claims relating to salmon farming. So I think that complaint is focused on the use of phrases like responsibly sourced or responsibly farmed, and trying to unpack what that really means to make sure it's not misleading to consumers.
Indeed. And finally, Nicola, is there anything else that the CMA have on their plate at the moment that we should be aware of?
Yeah, I think so. It would be strange to do any competition webinar at the moment and not mention the Digital Markets Consumer and Competition Bill. And that kind of it's a very large piece of legislation. It's getting through the final stages of the parliamentary process right now, and it will come into force in August. And quite a lot of the CMA's attention is very much focused on that bill and preparing for it. A lot of the discussion about that bill has really been focused on the introduction of a new regime for digital markets. So I guess maybe in this sector, it might feel that sometimes as though the CMA and all the competition regulators have got so much attention focused on big tech and the regulation of big tech and, all of that space, and so that's maybe feels like it might be to the exclusion of other areas of interest, but I'm afraid that's not the case. The DMCC bill is so big, as well as the whole digital regime piece, it does actually introduce a number of important changes to aspects of competition or enforcement and procedures, investigation procedures, in particular by strengthening some of the CMA's investigation powers, for example, in relation to dawn raids, which are still very firmly on their agenda.
Thank you, Nicola. And that neatly moves us on to the CMA's topic of their enforcement activities. So I'd now like to welcome Simon to the floor. So Simon, what are dawn raids and why should food and agri businesses be worried about them?
Yeah, thanks, Craig, and good morning, everybody. So one of the CMA's functions is to investigate and enforce anti-competitive behaviour by businesses. And dawn raids are one of the ways that the CMA has to gather and preserve information and evidence to assist it in its investigations of anti-competitive behaviours. And so before we get into some of the details, I'd just like to reassure you that usually these raids aren't actually at dawn, which will be a relief to everyone, especially at this time of year. Usually they take place between 8 and 9 in the morning, when at least there's a chance that people in the offices will be present. So as Nicola says, the CMA is very interested in the food and agri sector. So dawn raids by the CMA is very much a business risk for food and agri businesses. Despite Brexit, the CMA will also assist the EU Commission and EU national competition regulators with European-wide investigations. So these regulators are also active in the food and agri sector. In March 2003, the Commission raided the premises across Europe of an energy drinks manufacturer. In November 22, the French authority raided a number of dairy businesses across France, and the EU Commission has been investigating Mondelez and is expected to fine it for, in effect, carving up EU national markets by restricting parallel imports of its products between member states. So very much, both the CMA and regulators overseas very much alive and see the importance of the food and agri sector for them.
And so Simon, what powers does the CMA actually have to enter premises?
Usually the CMA enters premises with a warrant. There are a few other mechanisms that they can use, but by far the most popular, at least with the CMA, is to enter businesses with a warrant. And they, of course, they do this unannounced, as the name suggests. It's a little bit alarming to note, but most dawn raids actually happen on a Tuesday, because what the CMA has done on the Monday is it's travelled up to your premises, and it's probably even driven past just to make sure that it knows where the car park is and where the front door is and what have you. And that's what they do on the Monday, so that on Tuesday morning they're there, at opening hours to knock on the door. I mentioned business premises, but the warrants will usually extend to domestic premises, where those premises are used by the business or where documents might reasonably believed to be kept. And this is, of course, very much an increasing thing with hybrid working. So there's been a case in the High Court about this recently, and which the CMA and the court, in effect, confirmed the CMA's rights to enter into domestic premises, and those rights were the same as to enter into business ones. And the chief executive of the CMA said that with the increase in remote working and electronic communication, it's essential that the CMA is able to search domestic premises to secure evidence of potential breaches of competition law where it's appropriate to do so, so that they see no difference, especially now, between the office and working from home. Once in the premises, the CMA has the power to require the disclosure and the production and to take copies of specific documents. And this includes of your IT systems. So IT very much more important now than in the dare I say it, the good old days where they would sit there and wade through files of paperwork. They are able to access documents which are both in the UK, and they can access IT systems to find those documents, even if the documents are actually on a server that is outside, that is outside of the UK, but nonetheless accessible from your UK office. And the other power is that the CMA has the right to ask factual questions. So this is a case of, they might notice in an email that the SLT meeting is at such and such a time at such and such a place, and they'd be entitled to require you to explain what SLT stands for. What they are not allowed to do is to go on a fishing expedition. So you might remember a minute ago I mentioned about the warrant. The warrant is a critical part of the dawn raid, and the CMA's investigations and requests for documents and any questions that they have of people must always be within the scope of the warrant. So the CMA must not use these dawn raids to go on what's called a fishing expedition. Nor are the CMA allowed to see or take copies of legally privileged documents. So these are essentially documents between you and your lawyer, both external and internal lawyers, where the business is receiving legal advice. Also, the CMA, I mentioned questions. The CMA can't require the company to incriminate itself. So it shouldn't be answering questions like, so are the SLT meetings, is that where the prices are fixed, for example? They can't be doing that. The CMA's main concern is going to be that evidence is not destroyed. They will be entitled to see all sorts of documentation, correspondence and emails, voicemails, diary entries, particularly popular, because what the CMA has done in quite a few investigations, as it has married up the diaries of various people in various organizations and noticed that they're all sitting beside a service station on the M6 at all at the same time, and that's very valuable evidence for them. Any internal documents and even travel expenses. Again, this is all about trying to find where senior people are all at the same time.
So thank you, Simon. So for the benefit of all of the participants on this call, what 5 things should businesses remember when the inspector calls?
Yes. The first thing, and at the risk of stating the obvious, is to let them in. They have the right to come in, and if you don't let them in, that is just going to be, that is going to be very obstructive, and there are sanctions against obstructing an investigation. And also, they don't like to be kept outside, so you've got to let them in, and that then at least doesn't make them even more grumpy than they are. You should sign them in as visitors, and if your site has particular, reasonable health and safety instructions and inductions that visitors have to go through, you're entitled to make them go through those. I mentioned the warrant. Check the warrant. Occasionally, it does have, they've come to the wrong address or they've not got the right company. Usually they've put so much work into it that it's absolutely fine. But it is worth a check. Check what the scope of the investigation is, because that will be important later. You'll need to contact the senior leadership team, the IT leadership team as well. So remember the importance of IT, in-house legal if you have it, and or your external legal advisors, and send those people the warrant so that they can check it as well. Fourthly, reassure inspectors that you will cooperate with their investigation. Find them a room that they can use. So you'll have to block out one of those for the whole day. and then ask them to wait for legal advisors to arrive. They may or may not wait. They don't have to. If you don't have a lawyer on site, either in-house or an external lawyer on site, then they might wait up to 30 minutes. But as I mentioned before, what they're concerned about is that evidence is not destroyed and is preserved. So they won't wait very long. And if they even think about, that some people are deleting emails out the back while they're at the front door, they will want to move on. And fifthly, if they do move on, then shadow each inspector. So each inspector, in effect, should be man-marked all around the building. They shouldn't be going to places on their own. The shadowers should take detailed notes of what the inspector asks for, what they see, and what they copy. And the purpose of this is to gain as much insight as possible into what the CMA is looking for, and also it's get an idea of what information they already have. So they might come back to recurring themes and their questions.
That's really helpful guidance, Simon. And just looking at some other practical helps and tips, what are the key points that a dawn raid policy should cover?
It really builds on the things that you should do when the inspector calls. So it's going to be who will need to respond to the raid. How are you going to get the senior leadership team to the site? So who are you going to call? What are their contact details? And have a few alternative telephone numbers, etc. Also, in-house legal, the same goes for that. Key here is reception, and often forgotten. Everyone remembers to call the MD, call the general counsel, call the lawyer, etc. But actually, the first people that the CMA are going to see are the receptionists. And so the receptionists need to know how to deal with them, finding them a room, getting them to sign in, etc. All very, very important stuff. You'll need to get public relations people on board. Usually, the business would want to make a fairly bland statement about the raid, and also you need to know who is going to shadow the inspectors before external lawyers can come and add some numbers. So for each of those people, what are they going to do during the raid? What are they responsible for? Who's going to deal with the lead inspector? It's important that I mentioned IT and the importance of that earlier. It's important that any auto deletion routines for the IT system are halted. Like I say, the CMA is keen that evidence is not destroyed. You might want to have a template staff briefing ready to go. It's important that staff don't, the raid is confidential to the business. It's important that staff don't tell anybody else outside of the organisation what's going on. And lastly, the policy should set out the wash up, so what to do after the investigators have left.
Great, thanks, Simon. Some really helpful pointers there. Turning now to Kate's session on the CMA's approach to mergers and acquisitions. Kate, what trends have you observed in merger control in the food sector in the UK?
Thanks, Craig, and good morning, everybody. So I thought I'd start off my session by just looking at some data, which I've taken from the CMA's case page. And specifically, I've looked at cases concerning mergers in the sector since 2020. Listed on the case page are 12 cases, both a selection of open and closed cases concerning food manufacturing and agriculture. And I suppose the first point I would say is that the things the CMA has looked at has been really broad. So the kind of products that the CMA has reviewed include breakfast cereals. So we've had a case around granola and porridge. We've had a case on bottled water, the farming and processing of Scottish Atlantic salmon, supply of chicken products, a case concerning the supply of poultry feeds, There's been a case concerning the slaughter of live cattle and lamb and the processing, packaging and supply of cattle and lamb products. There's been a case around seafood products, breaded scampi to be precise, and also dough to bake products. I mean, that's not an exhaustive list, but that's just to give you a flavour of really the very wide variety of merger cases that have been across the CMA's desk in the last 4 years. And I suppose then digging down a bit deeper into outcomes of those cases. Based on our calculations, around 58% of cases have been cleared unconditionally by the CMA at the end of phase 1. So that's the first kind of initial filter as to whether a transaction raises competition problems. And the balance, around 42%, have involved some form of CMA intervention at the end of phase 1, in the form of either the CMA accepting binding commitments from the parties to remedy the competition issue that has been identified, which in reality means a commitment to divest something to fix the problem, or alternatively, the CMA deciding to refer the case to a detailed phase 2 inquiry. So I suppose taking a step back and looking at those stats in comparison with all cases over the same time period, but not just limited to food and sector. I mean, what can we see? I mean, each year you see the numbers of clearances versus intervention fluctuating with some years, that the balance being in favour of clearances versus interventions, and in other years the balance flipping, and actually more cases requiring some form of intervention rather than clearances. But nonetheless, if you sort of take a look over that time period on an average basis, clearances in food and agriculture merger cases are actually ahead of general trend. So 58% clearances versus 46% if you look at all cases in the round. So good news for food and agribusinesses here. And the proportion of cases in which the CMA intervenes at the end of phase 1, so around 43%, is broadly aligned with cases in all of the sectors. So what can we take from all of this? I mean, I suppose I should start by saying that every case does depend on its facts, on the evidence. The CMA, the review it conducts at phase 1, as indeed at phase 2, is evidence-driven and data-driven. So the decisions that are made really do depend on what the evidence shows and what the CMA's mergers and team and economists make of it. That being said, however, I would say, I'm really reflecting on what Nicola said in her session, thinking about the CMA's strategic priorities around hard-pressed household budgets, the cost of living crisis, for example. We've certainly heard that from the CMA in cases where we've been active, we've represented clients. Food is inevitably of interest. I mean, it has a direct consumer nexus, and therefore it seems to us that merger cases involving food and agriculture are likely to remain pretty high on the CMA's radar going forward, which means in reality for anybody on the call who might be thinking about a transaction or thinking about a growth strategy in the future, that getting to grips with the competition risks and thinking about what that means in terms of an appropriate strategy with the CMA really is very important for deals in the sector.
Thanks, Kate. When assessing whether a transaction is likely to raise issues, what factors are red flags, meaning that the CMA is more likely to intervene?
Yes. So I think the cases in the food sector are really quite interesting from that perspective. But before I get into what the red flags might be, I thought it'd be useful for everyone just to remind attendees about what the CMA has to ask itself. So at phase 1, the CMA has to decide whether there is a realistic prospect that the transaction in hand would result in a substantial lessening of competition in a market in the UK or a substantial part of it. So thinking about what that actually means, essentially the CMA is asking whether, as a result of the merger, customers will be worse off in some way. So, for example, would they pay higher prices, or could they receive a sort of a lower quality of products or services, or would innovation, for example, in the sector be reduced, ultimately causing consumer harm? Now, when you look at what the CMA's been considering in recent times, and thinking about the digital focus, which Nicola mentioned in respect of the new bill that's going through Parliament and is soon to be enacted, there has been an awful lot of discussion around really sort of novel ways of assessing mergers in the digital sector, with all these kind of buzzy new words flying around about ecosystems, theory of harm, and pinwheel theory of harm. I mean, it's been quite extraordinary. When you look at sort of mergers in the food and agriculture sector, you see very much more a kind of traditional approach, if I put it that way, from the CMA, really going back to the building blocks of sort of competition thinking and policy. So the kind of things that we see the CMA looking at, which may raise red flags in cases, include, for example, whether there would be significant market shares post-merger. So roughly speaking, anything more than 40%, for example, a finding that the parties are close competitors by reference to actually what do they actually supply, but also to whom do they supply their products or services. So are there overlaps in terms of their customer base, in terms of retailers or food service customers, for example. And I would say here that documents that the parties produce and who talk about who they compete with and how they see themselves in the market continue to be a really rich and fertile source of evidence for the CMA, and really very, very important. Other factors which might be red flags would be a finding that the market is concentrated, so there are a limited number of players in the market, raising the concern that post-merger there would be a limited number of others in the market capable of exerting a discipline on the merged business after completion. Evidence that capacity is full up can be important. Innovation, my experience is that innovation is possibly less important in these sectors compared to, say, digital and technology, where product evolution can be fast-paced, and therefore the CMA tends to take a very dynamic view. But nonetheless, parties should remember that the kind of traditional static snapshot of this is competition today is not the way the CMA looks at the world. They have a very much forward-looking dynamic view, and they want to know where would the parties be competing with each other in the future absent the merger. And last but by no means least, and this is really important, it's nothing new, but if there are third parties out there who are likely to raise complaints, customers in particular, then these can weigh very heavily on the CMA's mind and on the CMA's findings. So there's a whole host of things to think about which could raise a red flag.
Yes, indeed. So what are the key takeaways for businesses in the sector when planning for a transaction?
Well, first and foremost, it's important to remember that there is absolutely no obligation to tell the CMA about a merger that qualifies for review. The UK's merger regime remains voluntary, so it's all about risk assessment by the merger parties. But I would say two things in connection with that. So first of all, the CMA has the power to call in completed mergers for review, and at the end of a review can order remedies, so could even order that a transaction is unwound. So that raises the stakes to a pretty high level. And secondly, as I said earlier, the sector does remain of very real interest to the CMA. The CMA has a team, internal team called the Mergers Intelligence Committee, whose purpose in life is to monitor transactional activity across the economy. They look at hundreds of deals per year. And therefore, when you take into combination both the sort of policy drivers behind the CMA's thinking about household budgets, etc., and this kind of vigilance in terms of market monitoring, the risk of the CMA becoming aware of a transaction in the sector, I say, is very real. And this is the regulatory environment for deals in this sector. So I suppose that's the backdrop. As I mentioned right at the beginning, the data shows that when the CMA does look at cases at phase one in the sector, the intervention rates are relatively high. And therefore, for me, this means that deals in the sector which might raise substantive concerns, in really planning that regulatory strategy early in the piece is very important. It needs to be up there on the deal checklist. In terms of identifying potential hurdles and thinking about how best to overcome them, which does mean, deep dives into the data and the evidence, looking at what the CMA would look at and thinking, well, what does it show? What would the CMA make of it? And this also translates into ultimately how risk is allocated as between the buyer and the seller. I said earlier about internal documents. Again, I would say this is a key takeaway. Internal documents are a key source of evidence. And so if for businesses that might be planning an acquisition strategy, reminding your people about what they write in their documents and just being mindful of putting something on paper which might be open to misinterpretation or misconstruction by the CMA, will be time well spent to avoid then having to try and explain away some potentially unhelpful statements. And last but by no means least, our experience of the phase 1 process with the CMA is that the pre-notification stage, which is a compulsory and also a critical part of the process, does tend to be quite long these days. The CMA does take the time to really delve into the detail and to really try and understand what's going on. So in terms of planning, you really need to allow enough time for that in your deal timetable, just to manage everybody's expectations.
Thanks, Kate. And just on that point you were mentioning about the CMA being particularly vigilant in monitoring transaction activity. As a corporate lawyer who specialises in the food and agribusiness sector, I even received an email directly from the CMA, which scared the wit out of me, inquiring as to whether I'd been involved in a transaction that they'd uncovered. Thankfully, in that instance, I hadn't been involved in that one, so I was able to go back to them and say not guilty. But just goes to show how active they are.